This is a special report from True Crime Today and the Hidden Killers podcast.
Tony Bruschi, thanks for joining us. Lori Vallow Daybell back in court again today. The judge to hear arguments on cameras in the courtroom in her upcoming murder conspiracy trial. Let's go to the courtroom and take a listen.
All right, this is State of Arizona versus Lori Daybell, CR 2021 001704, CR 2022 001242.
Pretty K on behalf of the state. For the record, the next of kin in the 2021 and the victim in the 2022 are appearing virtually.
Good morning, Your Honor. Pamela Hicks, advisory counsel on behalf of Ms. Daybell, and Robert Abernathy is out of the office today.
Okay. You want to announce?
Lori Daybell, on
Thank
behalf
you.
of myself.
All right, we have a number of things to get through this morning. The first thing I want to address is there's been multiple media requests. I don't know if there's a representative of the media that can address this, but my question is if there's a single pool camera, is there some sort of agreement or cooperation between other media outlets to use a single camera?
Your Honor, if I may, Matthew Kelly, I represent Court TV, and our understanding is that, yes, there is a pool arrangement, and Court TV has asked to be the pool for the trials in this matter. I believe that that request is pending with the PIO. Regardless, the media that are interested in camera coverage do have a pool arrangement.
Okay. I know that there was, I don't know if it was Court TV or another outlet requested multiple cameras and a still camera. I'm inclined to just allow a single camera. Do you want to speak to that?
Yes, Your Honor. Court TV would prefer to have two of its own cameras. One of its own cameras is perfectly fine. Court TV's equipment is actually smaller than the camera we have here today and can be operated remotely, so it is much more unobtrusive. Court TV also has, in the past, used the feed from one of the cameras here for the webcasting of hearings for its purposes as well. Court TV will position its camera so that jurors are not in the field of view and would not use any of these cameras that have a view of the jurors.
All right, thank you. Is there anyone else here from the media that wants to be heard? I don't hear any. State want to take a position?
Your Honor.
All right, I know the defendant filed an objection. I've read your objection. Do you have anything you want to add to that?
Yeah, Your Honor, I'd just like to add some case law to that. Shepard versus Maxwell, 337 U.S. The United States Supreme Court, Mr. Justice Clark, held that failure of the state judge in murder prosecution to protect defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process. So that and Arizona versus Cheney, which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced to the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Your prior attorneys had filed a series of objections to media coverage media being allowed in the courtroom, and I made a prior ruling that was filed back September 4th, which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow. But essentially, there won't be any media coverage during the jury selection process, and I'll put the reasons for that in the order. So that's, again, I'll issue a more detailed order later today or tomorrow. All right.
Your Honor, there's also the issue of whether Court TV will be allowed to live stream the trial. in other words, broadcast online in real time. Court TV would prefer to do that.
Are you able to, are they able to do a 1 or 2 minute delay?
Certainly, we can certainly do that. I just want to inform Your Honor, however, that when we share the footage with the pool, we can't delay that footage. So your order would need to require that all media receiving the feed delay it by, however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requests it?
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
It's prejudicial and it's going to be his fault.
All right. Thank you.
Thank you.
All right. Let's get down to business on some of the...
Your Honor?
Yeah.
Could I just add that we want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think.
All right. Well, my draft already includes that there'll be no zooming in on counsel table, anything on counsel table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state, are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have do you have the names of your designated victim or victim representatives that might be testifying?
Kay Woodcock is a statutory legal victim and will be testifying.
Is that the only one?
At this time, yes.
Okay.
For this trial, I should say.
For this trial. Okay. Let me ask this. Are the parties ready to proceed around March 31st or April 1st?
Yes.
Yes, Your Honor.
All right, let me ask the state next. Earlier during these proceedings in past hearings, you indicated you thought the state's case in chief would take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3 weeks.
Okay.
But I did say that while we had a defense attorney on and not Ms. Vallow herself. I am familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned. So in order to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
So now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount of cross? I know that's hard to estimate.
And again, I would say 2 to 3 weeks.
Three weeks?
That would be at the outset of it.
Okay.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop in going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of times the courts send us back to our office to go through that. So if we do that here, then yes, of course, she's welcome to use our laptops.
All right. My plan is we can do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we'll have. We can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
And obviously, Your Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the mornings, the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
Well, we have on this floor 6 rooms, 5 or 6 rooms throughout. We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper contact between media or the public in general and any victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an e-questionnaire, remote questionnaire for the first 200 jurors. That questionnaire, I need to get a final joint pretrial statement with the list of witnesses to include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. Let me bring up my calendar.
How many questions are we going to be able to?
We would probably send that out to the first 200 jurors around next Thursday, March 20th. Yeah.
Because of the way they send this, the first day they can send it out the 24th.
Oh, I guess they can't send it out.
So we can do from the 24th to the morning of the 27th.
Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can. Oh, that's right. I back up. The initial answers for the remote, we're going to meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in-person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They don't have a capability to do it remote. So we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized. The list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do a panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the e-questionnaire that goes out remotely, but on this case I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Well,
it's going to be complicated.
all the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name's going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether
Sure.
we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. The state indicated, I have it, there was just one day in April that you wanted to go a half day.
Correct, Your Honor. The 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor. We will have both, obviously, with self-defense, trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence. So, all right. Any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection? Is that correct?
We'll be meeting on the 31st,
Okay.
and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Robert and I.
let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please let us know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So into let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
And one more time, Your Honor, so the remote question is going out on March 24th. All answers have to be back by the 27th, so we will get them on the 27th? Or
You'll either get them late the 27th or first thing the 28th.
Okay.
In the morning, late in the morning of the 27th.
Oh, okay.
Okay.
So I'll put it-
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 a.m. on the 27th.
You'll have to have a internet connection.
Yeah, we
out there.
can use
Okay.
our laptops out there.
Okay.
Because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to.
So we'll come out on Friday and go through the questionnaire. We don't get any questions on that.
All right, the defendant had filed 2 separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
All right. And I'll ask the deputy county attorney. I imagine some communications are by phone. So in other words, we're not captured.
Correct, Your Honor.
All right. Based on the state's avowal, I don't know. I can't tell them to turn over something they say they don't have. So I'll find that the state, based on their avowal, and officers of the court have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one. And the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
I mean, we disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
Let me see if we can find the actual
Maybe the discovery notice.
discovery letter.
Okay.
That's the latest. Lori Vallow Daybell in the courtroom. Be sure to press subscribe wherever you download podcasts. You don't miss any of our continuing coverage on this case and the others we're following for you right here at True Crime Today and the Hidden Killers podcast. I'm Tony Bruschi. Stay with us.
This has been a special report from True Crime Today and the Hidden Killers podcast.